In this video, I will explain purchasing laws and ethics. I will start with a problem. If a company's procurement manager makes a costly mistake, then who would be liable, the manager or the company? How do we make these type of decisions? We need a framework to understand these type of decisions, and that is the topic of this chapter. Here's a theory that's called as agency theory. The idea of agency theory is that an organization could be considered as a nexus of contract among self-interested parties. There is a principal and agent. A principal is the owner of a business, and the principal appoints an agent to run the business on their behalf. For example, if there is a restaurant, the owner of the restaurant would be principal. They may appoint a manager who would be running the restaurant on their behalf. So the manager would be agent. The fiduciary responsibility of the agent is to act in the best interest of the organization. In case of supply management, the procurement manager is an agent who works for the company, and therefore procurement manager would be an agent. The framework that we will use for this purpose is called as actual versus apparent authority. Actual authority is the one that's formal authority bestowed upon the agent by the organization. And then there is another term that's called apparent authority. Apparent authority is the type of authority that appears to be. A procurement manager appears to have some authority, whereby it seems that procurement manager can make these type of transactions, purchasing decisions. This type of perception, which means that procurement manager appears to have the authority to make purchasing decisions independently. This perception results from company's actions or communication, whereby a procurement manager is presented to the suppliers or other people such that they believe that procurement manager can make these decisions, which mean procurement related decisions, independently. There are four types of combinations, and the first one is that whereby a procurement manager is acting within apparent authority and also within actual authority. So which means there is nothing wrong, because actual authority, that's not being exceeded. So therefore that's perfectly fine, nothing wrong with that. A second situation could be that the manager is exercising his powers within apparent authority, but actual authority is exceeded, which means organization had not bestowed that power which manager used, but maybe organization gave some type of signals whereby suppliers perceived that the manager has that authority. Now in that case, organization or employer or the buyer is responsible for performance of contract. A third situation is that whereby apparent authority is exceeded but actual authority is not exceeded. Since actual authority is not exceeded, procurement manager is acting within actual authority, so therefore there is no problem. And the last one is that where apparent authority is exceeded and actual authority is also exceeded. Now in this case, whereby a procurement manager goes beyond apparent authority and also goes beyond what the organization had mandated. In that case, purchasing manager is liable and there may be dire consequences for their actions. So this is a framework that explains when procurement managers make decision, we use this framework. And just to keep things in perspective, it is possible that managers can be held liable. One example of this one is Volkswagen. Volkswagen had this scandal that's called as Dieselgate scandal. The background of this scandal is that Volkswagen, it's a German company and it's a very good company. They make very good cars. But because of very tough competition they are facing from Japanese car manufacturers, American car manufacturers, and Korean car manufacturers, they did deception. Some of the managers installed a software in the engine with the intent of deceiving. The software would detect the car is now being tested, so it would release less smoke and less greenhouse gases. But as soon as the software senses it is on the road, it's running, the car would start releasing a load of greenhouse gases and smoke. So which mean when you are testing it, you get different results, and when car is actually on the road, when you are actually using it, then it gives different amount of greenhouse gases, and that is deception. And when regulators found it, there were penalties for Volkswagen, and those penalties were in billions. And one of the manager, Oliver Schmidt, who is the chief engineer at Volkswagen, received 7 years jail time and a $400,000 penalty. So there is a possibility that procurement manager, if they exceed their apparent authority and if they also exceed their formal authority, which means their actual authority, it means they would be held liable. And actually, this is an important point because sometimes people think that managers, they cannot be held liable because most of organizations like Volkswagen considered as corporations. Corporations is considered as an independent entity, which means if something goes wrong, it is corporation is liable. Managers are usually not liable. Their personal wealth is safe. However, in this case, managers arrested, they were fined. The reason is that because regulators were able to prove that what managers exceeded their apparent authority and they also exceeded their actual authority. The next thing is the contracting process. In the contracting process, it starts with a request for quotation whereby a buyer would prepare a request for quotation and it would be sent to supplier, and supplier would provide quotation, and then if there are multiple suppliers, there would be negotiations and contract bidding. Once all these things are finalized, contract is awarded and purchase order is issued and contract administration takes place. A contract law is a set of promises whereby law expects that when two parties agree on a contract, they fulfill that contract. If there is a breach, then law would provide remedies for that. And a contract comprises three elements: an offer, an acceptance, and consideration. An offer is that's a proposal or expression by one person that he or she is willing to do something for certain terms. Here's an example. Betsy, the owner of a retail electronics store, contacts Tech Data Corporation and says that I want to buy 50 Surface Pros from you and I will pay you $400 for each Surface Pro if you deliver them to my place of business on December 1st, 2024. So that would be an offer. A supplier would accept that offer, and that acceptance could be through email, mail, fax, or any other form of communication. Essential component of a contract is consideration, which means some exchange is happening in every contract whereby both parties agreeing to give something. In this case, when Betsy says that she wants Surface Pros, Betsy will be paying $400 for each Surface Pro and supplier will be providing 50 Surface Pros. So both parties are giving something and receiving something, and that's called consideration. Another example would be that if a person A agrees to sell a car to person B for $5,000, now one person would be giving away $5,000 and other person would be giving their car. So an exchange is happening, and that part is called as consideration, and that's an essential component of any contract. And the last part is that in a contract, the person who executes that contract must be a competent party and there is mutual assent, which means mutual agreement. The one who executes a contract must be either a principal or a qualified agent. So a principal, which means the owner of a business, execute this contract, or a qualified agent, which means the procurement manager. So procurement manager is the agent. It is expected that the one who executes a contract must not have engaged any fraudulent activities when formulating the agreement, which means the contract was done with a good intent and with free will, which means there is no force or coercion. Both parties are planning to execute and abide by the contract in good faith. Now, there are some major parts of a purchase order, which mean a purchase order would specify fixed prices and quantities and taxes, then buyer's right of inspection and rejection, right to make specification or design changes, holding buyer harmless in case of patent infringement. Now this means that if a buyer is buying something from a supplier, but supplier does not hold patents for that and some infringement happens, the whole responsibility is on the supplier. Supplier's right to assign the contract to a third party, that will be discussed in purchase order, instructions regarding risk of loss and how payments will be made, and packing and preparation, statement of warranty, shipment quantity and when they would be received, assignment of seller's right, and if something goes wrong, how that problem would be resolved, and right to cancel unshipped portion. And then there's some boilerplate terms and condition which are usually mentioned on the back of the forms, which state all the terms and condition, for example limitation of liability and force majeure and termination clause, arbitration clause and entire agreement. Entire agreement means that the contract will be executed in its entirety. Force majeure is also known as hand of God, which means if some type of circumstances happen that are beyond the control of a supplier, earthquake happens and all supply chains are disrupted and a supplier is unable to fulfill the contract. For buyer, maybe their production is stopped and they are incurring a loss, but in that case they cannot sue the supplier because supplier cannot do something. All supply chains are disrupted because of earthquake. Then the next thing is cancellation of orders. There are three categories: cancellation for default. If a supplier fails to fulfill the contract, then that contract can be cancelled. Failure of one party to live up to the terms and conditions, for example, late deliveries or failing to meet product specifications. Then the second type is cancellation for the convenience of the purchaser, which means terminating the contract without any specific fault or default on the part of the supplier. For example, if a buyer feels that they do not need that raw material anymore and they cancel the contract, the buyer is responsible for all the damages to the supplier. And the last thing is cancellation by mutual consent. In this case, because cancellation happens by mutual consent of both buyer and supplier, so therefore that would be considered okay. And breach of contract. Normally, a seller is obligated to deliver goods according to the contract's term and condition, and buyer is obligated to make payments accordingly. However, a breach of contract occurs when either party fails to perform its contractual obligations, and breach may entitle either party to certain remedies or damages. When we talk about damages, the first one is liquidated damages. Liquidated damages are predefined, pre-agreed in the contract, which means the contract defines if things go wrong, then what type of damages a buyer or supplier will pay. For example, in a construction project, the contract can say that for every week the project is delayed, there will be a penalty of $5,000 per week. And when this is defined upfront in the contract, that would be an example of liquidated damages. The second thing is being made whole, which means if any problem happens, if a breach happens, then the buyer or the party who suffers, they need to be brought back to the original condition. For example, if an accident happens and there's one driver who is at fault, the driver who is at fault, their insurance company is responsible for the damages of the other driver, their medical expenses, if they have lost any wages because of not being able to work. So basically, the idea of this being made whole is that you need to bring back to the original condition in order to compensate. Bring the buyer back to a position where he or she would have been had the breach not occurred. And then actual versus punitive damages. In punitive damages, a buyer, for example, if it is the fault of a supplier, a buyer may wish to impose some penalty on supplier, but UCC, that's Uniform Commercial Code, does not allow punitive damages. Now here is an example. Suppose the deal for buying Surface Pro is finalized. Betsy paid $2,000 as a down payment to the supplier. Betsy is the buyer. Betsy also spent $5,000 reconfiguring new display shelves in her electronics store to display and store the Surface Pros. So which means she asked a carpenter and they made some shelves, and Betsy paid $5,000 to the carpenter. Betsy is expecting to make a profit of $10,000 from this investment. If the supplier fails to provide these order, supplier is responsible for not fulfilling this contract. Now in this case, what would be the nature of damages? First of all, this $2,000 which Betsy paid, supplier has to return it, and this is called as restitution damages. And then Betsy had also spent $5,000 to make shelves, so that would be called as reliance damages, which means Betsy was relying on the supplier, that supplier would provide Surface Pros and she would be using those shelves. This $5,000 would be reliance damages. And then Betsy was expecting to make a profit of $10,000 from this investment. The amount of damages to the supplier would be $2,000 as restitution damages, $5,000 as reliance damage, and $10,000 as expectancy damages, which means supplier owes $17,000 as damages to be paid to the buyer. Can Betsy ask for punitive damages, which means going beyond this $17,000? UCC, which is Uniform Commercial Code, does not allow that. Now we will discuss some laws and some institutions that may have a role in purchasing and ethics of purchasing. So first of all, Uniform Commercial Code. Uniform Commercial Code, or UCC, is a set of laws governing commercial transactions in the USA. All US states have adopted UCC except Louisiana. UCC does not apply to international contracts because it is a national level code, and UCC acts as a gap filler. If two parties are having a contract and if there's some ambiguity, then clauses of UCC will apply. There are many clauses of UCC, but two clauses, sales of goods and products, and warehouse receipts, bills of lading, and other title document. These are two clauses that are particularly relevant to purchasing. So basic elements of clause 2 of article 2 is that about warranties and seller's right and buyer's right. Now regarding warranty, the first type of warranty is express warranty. Express warranty is that any affirmation of fact or promises made by the seller to the buyer which relates to goods and becomes part of basis of bargain creates express warranty. And one thing to consider over here is that many times sales agent, they exaggerate. Sometimes they try to puff up, and it is not illegal, but it needs to be taken into consideration. And then there is implied warranty. In contrast to express warranty that's clearly documented, implied warranty is that which is understood. It may not be documented. For example, if you buy some electronics items, then implied warranty states that they are supposed to serve their purpose. A refrigerator is meant to cause sufficient cooling with no electric shock. And then warranty of title. It indicates that supplier warrants that it has title to goods and that they are not stolen or subject to any security interest or liens, which means supplier has ownership. Buyer needs to take necessary steps to ensure proper transfer of title and ensure that seller has right to sell product. Then warranty of infringement, which means if at any stage it is found that the raw material that you have received or some components that you have received from the supplier, there is some issue with that. In that case, again, the basic principle is that supplier would be held responsible and buyer would remain harmless. Suppliers guarantee that goods do not illegally infringe on another party's patent protection. If they do infringe, costs and penalties are extremely severe. Contract must have adequate patent indemnification language to prevent this. Now, when we talk about institution, there are some institutions that can regulate purchasing or purchasing related decisions. Federal Trade Commission (FTC) is perhaps the most important institution that has a role in this one. And FTC addresses unfair competition and unfair or deceptive trade practices. So Federal Trade Commission makes sure that rights of consumers are protected. Unfair trade practices include those that allow large firms to gain an advantage over smaller rivals, predatory competition, and restraint of trade, and misleading or deceptive practices. Now, for example, you might have heard that Amazon is always on the radar of FTC because FTC believes that Amazon is a big company, it's a Goliath. It has many, many wings. E-commerce is one wing. Then they also have Amazon Web Services, and its pockets are very deep. And when a company grows so big, then it prevents other companies to enter in the business. Then there are some laws that are related to purchasing and implications of purchasing. Sherman Antitrust Act, it prohibits activities that are in restraint of trade, or it prevents monopolies. It also prevents actions like price fixing, dividing territories among competitors, and agreements that limit the supply of commodity. All these topics, they are subject of Sherman Antitrust law. The law also prohibits reciprocity and reciprocal purchase agreement. The next law that's related to this one is Clayton Antitrust Act. This law covers those areas that are not covered by Sherman Act, and more specifically, Clayton Antitrust Act covers price discrimination. It says price discrimination is illegal. Now, price discrimination, which essentially means that a product is being offered to different buyers at different rates, it is much more common than one can even think about. I would give you one example. Amazon at one time was accused of doing price discrimination, which means it was selling the same product to different customers at different prices. In e-commerce, all these purchases are made using some electronic gadget. Whenever you are buying something from Amazon, of course, you make an account whereby you give them every information. Amazon knows everything about you. They know your email address, they know your phone number, date of birth, what type of credit card you are using. Furthermore, cookies also know what type of computer and browser you are using. These cookies, they can determine if you are using a MacBook or a Windows-based operating system. When those cookies found that someone is using MacBook, that customer would be charged more compared to one who was using Windows. Exclusive dealing agreements. When a seller requires a buyer to purchase exclusively from the seller and not from its competitor, that would be a subject of Clayton Antitrust Act. The next one is tying arrangements, whereby a seller requires a buyer to purchase a secondary product as a condition of buying a desired primary product. For example, a computer manufacturer might insist that you also buy a specific kind of software from them. So in this case, the computer manufacturer is coupling hardware and software. Customer may be bound to buy both products from the same supplier. Now, that type of tying arrangement is a subject of Clayton Antitrust Act. And the last thing is mergers and acquisitions that lessen competition. Now, one very recent example of merger and acquisition that happened in January 2024, that was about a merger of JetBlue Airline and Spirit Airline. JetBlue Airline was trying to buy Spirit Airline for about $3.8 billion. But a judge blocked that deal because that would lessen competition. Robinson-Patman Act. This act prohibits sellers from offering discriminatory prices where the effect of discrimination may limit competition or create a monopoly. An example is that you are running a superstore and you are buying something from a supplier, and the supplier also sells to Walmart and Dollar Tree. You find that supplier is charging you more than they charge to Walmart or Dollar Tree. In this case, the supplier needs to provide an explanation that why they are discriminating. There can be a number of reasons. One reason could be economy of scale, which means maybe Walmart or Dollar General, they are buying in a greater quantity. If that is the case, then maybe it is justified. But absent other conditions, if the volume remains same, everything else remains same, then that would be a topic of Robinson-Patman Act. Sharp practices. These are type of practices which are technically within the bound of law, but there is some sort of deception and they are just short of fraudulent practices. For example, it could be willful use of misinformation, requesting bids from unqualified suppliers solely to drive down prices from qualified supplier. So a buyer may get quotes from unqualified suppliers, which of course would be low, and then that would be used to bring prices down from qualified suppliers. Gaining information unfairly through deception, sharing information on competitive quotations, and not compensating a supplier for design or other work, taking unfair advantage of a supplier's financial situation, and lying or misleading. The important point here is that these sharp practices usually technically within the bound of law, but they are unethical. Some element of deception is involved. Types of ethical behaviors which procurement manager or supply managers they need to avoid. For example, accepting supplier favors. If a supply manager or a procurement manager is accepting some gift, then they won't be able to make fair decisions. Therefore, buyers, supply managers should not accept any favors or gifts from suppliers. Reciprocity. You scratch my back and I will scratch yours. If you give me this favor, I will give you this favor. So that type of behavior is unethical. Then personal buying, which means buying something for yourself or for your employees. This is something, it's a gray area, which means in some cases it may be okay, but you need to exercise great caution here. Financial conflict of interest. An example would be if you buy from a supplier and it's a big contract and you also own stocks of the company of supplier, then that's a financial conflict of interest. When the supplier receives that contract, their share prices may go up and you would be a beneficiary because you own stocks. So therefore, it's important to make sure that there is no financial conflict of interest, or if there is a financial conflict of interest, then there should be a disclosure. And then personal conflict of interest, whereby a buyer is buying from a supplier and supplier is the relative, spouse, brother, sister, or any other relative. That would be personal conflict of interest and it should be avoided. However, if it's inevitable, then a disclosure statement would be needed. Disclosure of confidential or proprietary information is unethical. And the last thing is ISM, Institute for Supply Management Code of Professional Ethics. Institute for Supply Management is the biggest organization, the main organization that represents procurement professionals, and they have developed a code of professional ethics, and it basically requires that procurement managers should act morally and ethically. And this is the point where I would also like to invoke a distinction between morality and ethics. So whenever we talk about morality, it basically refers to the principles of right and wrong in behavior. Morality is more personal and it may be derived from cultural values and religious beliefs. But when we talk about ethics, it means systematizing right and wrong conduct. Now, for example, when medical practitioners are required to adhere to their professional code of conduct, which means we are talking about ethics. Institute for Supply Management has developed a code of professional ethics which all procurement professionals need to be aware of. So the first principle is that consider first the interest of your company. So because this is fiduciary responsibility of a manager, procurement manager, that they need to act in the best interest of the company. Be receptive to competent counsel from your colleagues and other people without impairing the dignity and responsibility of your office. Buying without prejudice, which means the fiduciary responsibility of a manager is to make good decisions that maximize value creation. And the next one is strive consistently for knowledge of the materials and processes of manufacture and establish practical method. Essentially, it means continuous improvement, because in every organization, in every sector, changes are happening every day. So a supply manager needs to be mindful of all the changes that are happening in their business. Then honesty and truth in buying, that's another core value. And then give a prompt and courteous reception as far as conditions allow to all who call on legitimate business missions. Respect your obligations and demand that your obligations are also respected. Avoiding sharp practices. Now, as I mentioned earlier, that these sharp practices, they are technically within the bound of law, but they are based on some misleading practices and therefore they are unethical. And then counsel and assist fellow purchasing managers in performance of their duties, and cooperate with all organizations and individuals engaged in activities to enhance development and standing of purchasing.